Now, keep in mind, the purpose of the presentation, you and your partner must decide on who's going to do the opening class and who's going to do the closing class. One of you will do opening, one of you will do closing. And whatever you do in class, you're going to flip for the trial. So if you want to do the closing at the trial, you need to do the opening in class. And vice versa. You know, you want to do the opening at the trial, do the closing for our presentation in class, and then for the trial, so you will be able to do it or whatever. Right now. Okay, so and of course I'll be keeping a note of that because that way by the time we get to the end of the semester, everybody would have done everything. Okay? Any questions on who's doing what? Now, what's the purpose of the opening statement?
Set the tone.
Ben Still? Sway.
More on your side.
Okay, that's a good start.
I kind of feel like it's like an introduction into like what's going on. It's kind of like the beginning of a story, you know, like the opening of the story, like kind of to catch the hook, to kind of draw you into like everything else that might go.
Okay, all of that's good. Everything is right. Yes, sir.
I was saying to set the tone of your argument.
What do you mean set the tone?
Like you to create a picture, to paint a picture about what you're about to speak about.
Okay, now, and we all know that if we had that first witness take a stand and they just said, you know, yeah, I'm John, and, you know, you're married to such and such, and they start talking, you'd be sitting there thinking, it sure would have been nice if they had given us a little bit of a, you know, preview as to at least what the case is about, you know, what the charge is or the claim, you know, and who the parties are, who we're supposed to be hearing from. That would certainly help, right? Well, that's the whole purpose of the opening statement, which is to give a roadmap of what you're about to see. So they can sort of, you know, be familiar with what's to come. They know who these people are, you know, that this is a company that's planning for whoever the people, they know who the parties are, they know the claim that you're bringing, and you'll know what has to be proven and what does not have to be proven in the case, and the evidence that you're going to have that will probably prove it, and what you don't have, and you're going to know the people who you're going to hear from in order to help prove the case. Now, here's the L word.
It's not.
Somebody try. So those are some of the main things that we're talking about. Now, just based on what you said, I would say that is correct as well. Now, we know that we have an opening statement and closing argument because the opening is not supposed to be argument. But at the same time, it kind of is because every time you talk to the jury, you need to take that opportunity to continue to persuade them a little bit. You need to inch more and more and more towards your case, whatever you're trying to prove. You need to take every opportunity to try to do that. Even in your voir dire, which you're not arguing or making a statement, in your questions, you start planting seeds that will help ultimately help the jury decide in your favor. Every opportunity. I've been having this issue a lot lately. All of a sudden, it just decides to quit. Then it's all gone. Starting to see that. You know, because even when voir dire, you might start asking the jury, you know, if it's a self-defense type of case, you might say, you know, what would you find to be a reasonable, what do you consider to be a reasonable use of force? You know, well, what if a person only had their fist, then what do you think should be reasonable, a reasonable use of force to defend yourself against that? So you might have jurors saying, you know, well, I think a gun, I think a knife, I think whatever. And you're already, the jury's already thinking, okay, well, that's probably what we have. Somebody's just fighting and somebody else is going to go overboard with the knife, and that's what they're going to be arguing. So at the end of the day, you know, you're planting the seeds in the jury's mind during your voir dire, and you continue to do that during your opening statement. You continue to, you know, sort of let them know what the case is about and give them the roadmap for the case and all also you begin, you know, the persuasion of your case. Now, for opening statements, there are mainly three parts to the opening statement. You need to keep in mind, with a little bit of sprinkling in and out. But the three main parts you need to know. One is the attention getter. You need an attention getter. Usually your attention getter is gonna, usually, doesn't have to be, but usually it's gonna encompass some kind of way your theme. Usually it's gonna come, it might, just something, you know, it may be a, you know, a little clip to begin with, just something that you say or do. I did clap, but something to get the juror's attention. Very early on, you need to say within the first couple of sentences, this is a case about, and your theme should be coming up very, very quickly. After you do the attention getter, you need a theory. Now, I told you all last time, if you learn nothing else about from the whole class, the whole semester, which is not true, but I said it anyway, then it should be this one thing. Does anybody remember? I'd say you could have an A and B right now, but then you wouldn't learn it. I won't do that to you. Anybody remember? It's a really important question. The question was, if that I said one day, said it so many times, one day I said, if you learn nothing else in the course of the whole semester, you should learn this.
Did it was like an element or something?
An element?
I mean,
Of what?
don't.
Not this year. I know, but that didn't stop me from getting my White House chocolate. You can't get this on that side of town. You cannot get this on that side. I go from McDonald's to McDonald's. They're like, it was seasonal. I'm like, the season not over. You have to get online and find. Okay, I've been to write a letter to McDonald's though. It's not gonna just give us this and that. But anyhow, oh yeah, back to the point. It was, you have to remember that this is the jury's first time hearing about this case. Now, you have been intimately familiar with this case for the last 2 or 3 years, or we don't know how long, at least about a couple of years. So you start to get up and talk to the jury as though you all are familiar, you know? Have you ever had a phone conversation or something like that with a friend? You're like, wait, hold up, back up. What are you talking about? You know, who is he? And, you know, you're not just going to get on the phone and say, can you believe she did it again today? Like, who is she and what did she do? That's the way you start to talk to the jury. And I think I went a step further and told you all that even grading exams, you know, professors have to do that. We're reading, you know, you read the next paper. You have to put out of your mind not only everything you know, but everything the other students have said in their papers, and you're looking at this one only for what's there, you know. And the students talk to you like you know. And you notice it a lot when you have somebody else writing typos, you know, like you have TAs and stuff writing typos, and now you're looking at, you know, answers from theirs, you really don't know what they're talking about. Well, when she swung it, you know, he ducked, so it wasn't a battery. Who is he, and what did she swing, and what was it? You know, they just, that's the way, and you will find, ladies and gentlemen, that I really hope you remember that, because there are seasoned attorneys who do that, and, you know, just forgetting and not realizing what was going on. You have to really be conscious of that when it's going on, when you're doing it. But the worst part about it, though, is this failed and missed opportunity. Because when you all do your openings next week, some of you are going to sit down and we're going to say, do you know what this is about? I mean, what happened? That's what we're going to say. What happened? What is the case about? you know, and so that's the second part of your opening, your theory of the case. You have to just tell us a story that your theory, whatever you're saying happened, we need to know. We need to get a factual scenario so that we will know what occurred. Some of you have the little Billy Bobby Brown, whatever the name of their case, with the motorcycle. And obviously there was an accident that happened. If you come up here and you only talk to us about, you know, it was that, you know, someone's life has been taken away now and, you know, they don't have a future anymore, and that's pretty much the only part of the story that you tell us, which is fine to tell us at the beginning, or wherever you want to tell it, but at some point we need to know about that accident. Same thing with the case with Burns. We had two different scenarios going on. We had what Burns said was really going on, right, which was him at home with his wife and kids for Mother's Day, but then there was also a robbery and murder going on. And so you got to kind of talk about, you know, as defense, maybe you don't want to talk about the robbery, you don't care, you know, about it because your guy wasn't there, you don't know about it. But whatever you're saying that's going on, we need to hear about it. We need a story. That's the second part of the opening statement. And he's going to have to get my presentation up here. And I'm just going to look at it on my iPad. These out there. Don't miss anything good. Now, I'm giving you a very, very simple outline, but one of the things about me is that, you know, when I want to hear something, or, you know, when I say it needs to be that way, I really need to hear that. I really want that to happen. So, I give you somewhere, I think on Twin, kind of like, it's for the trial. It says my checklist that I'm looking for, but I tell you here at the end of each exercise, I give you a checklist of what everything needs to have in it. In here, when you do it in class, I'm going to say that you were missing something that's on that checklist, and at the trial, those are the only things I'm going to be talking about. The things that's on that checklist. So you already know ahead of time what I'm going to be looking for, what I'm going to be asking for, just like in any other class. I'm always going to tell you exactly what I want. So if you don't have that, then all I can do is ask you the same question I've been asking you for a couple of years now, which is, why not? You know, why would you write that? Why would you say that? Okay, so that is what I'm going to be looking for. This, the statement of the facts is the theory, your theory of the case. You know, and we talked about, you know what the theory is now, and so we know that it's a factual scenario, what you say happened, but the theory needs to also do what? It definitely needs to make sense and be reasonable. Yeah, it should be persuasive to your side. It should be, we talked about it being rooted in the law, like based on the factual scenario that you've given. You know, the outcome should be in your favor, obviously, that I didn't pull the trigger or that I didn't have intent or whatever the case may be. And also, one other important thing that it needs to address some of these weaknesses that's in the case. And of course, it needs to be consistent with undisputed facts. You know, now you get to tell your theory. You gave us a brief summary of your theory the last time, but now we really want you to just give us and fully expound upon your theory. You know, tell us what you claim really happened that day. This is what really happened. You know, when we read things like, you know, a police report or even cases, we take that as these are the facts. Well, from your perspective, this is not what happened. What I'm telling you that happened, this is what really happened. We believe that. this is what we're gonna prove. And so law is not so much a statement of just reading the law, but it's about the theory of liability you're going under, what has to be proven, how it's gonna be proven. At some point, ladies and gentlemen, some of you are going to sit down, and we're not gonna even know if it's a criminal or a civil case. Especially a case like that Homer Simpson case, which really could be either one. We're gonna hear some facts and somebody got shot and blah blah blah. You're gonna be sitting down, and we don't even know we're looking to find somebody guilty or somebody liable. You know, the jury needs to know that, obviously. You have to think about those types of things now. That you're talking to lay people who do not know anything about the law and who know nothing about the facts. How would you describe this to them? Somebody who knows nothing about the law and nothing about the facts. You know, this person did something wrong, or he did not do something that he should have done. And throughout the course of the trial, we're going to talk about what he should have done. You know, you have to make sure that you let them know what happened, let them know the facts, and let them know what has to be proven or not. And then, of course, you want to talk to them about, excuse me, since I got some notes now, let me go back a little bit. The attention getter, we said, to grab the attention, give them something to hold on to throughout the trial, something they will not forget. Don't have to begin with good morning. You can bring that in later. We told you can start out with your attention getter. You can get up with your attention getter. And then after you introduce it, then you introduce yourself in co-counsel. Attention getter, good morning. I'm whoever, and I represent this person, blah, 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 blah. Okay, and as I told you, whatever. Okay, you know, use some variation, something unexpected when you get up. Something unexpected. Everything that happened here was because of revenge. That was this case is about. This is a case about taking responsibility for one's own conduct. This is a case about pain, or uncontained pain. This is just some examples of things that can be in your attention getter. Now, also keep in mind that an opening statement is not an argument. What does that mean? This is a difficult line for people to walk, because this is one of the main objections you're going to get in opening. Objection, Your Honor, he's arguing the case. That's always that thin line right here that you're walking in opening to keep from arguing the case. What does that mean? What is it? Did you all know the difference between just telling them what happened and arguing?
Well, in an argument, it's kind of more of like a back and forth, and y'all are like trying to like, you know, one up each other, or you know, make a better point than the other person.
But you're arguing by yourself now when you're doing your closing. How you argue by yourself? Yes, ma'am.
I think as opposed to like trying to prove a point, you're just kind of stating what you're gonna prove.
Right. That's first and foremost. You're just stating it. It is just a statement. In the open, you're just statement. Just a statement. You're just stating what's on your proof. Just telling it. This is the way it is. Now, when you get to your closing, it's more like when you're doing your analysis, when you're writing an exam. You know, you're trying to show how it is something or is not. You know, you are refuting, and also in open, you can keep in mind a good rule of thumb is someone gonna say, is somebody gonna testify to that in particular? You don't have to make any leaps. You don't have to make any inferences. When you start doing that, that's when you're arguing the case. How could he have gone in the house and come back out and gotten there in that amount of time? You're arguing. As opposed to saying that he went home, you know, took a shower, got dressed, and then he went back. It took him about 30 minutes to do that, and when he arrived, this is what happened. And you know, as opposed to, it's only 23 miles. You know, you can easily drive that amount in 15 minutes. So he was able to get home, change clothes, and get back there with no amount in that amount of time. You know, and so you're just telling them what happened in your opening. Now, the opening is really easy, and also keep in mind those who really like a big performance. You know, really not a lot to do with your opening. So don't feel bad, you know, that you don't get to really jazz it up too much because it's really just not that much you can do. That's your goal. That's really the only goal you can have is to get that attention getter in and lay out your theme. You got a good theme, and you know, it can sound great, you know, and then of course you want to lay out your theory of the case, and then finally, and I just have an example of the difference between arguing with a certain set of facts and, but I may have time to come back to that. Finish going through this. But, of course, in that last part, you know, this is a claim, you know, you may tell them, even in Homer Simpson, you might have to say specifically, you know, in a case like that, this is not a criminal case. I mean, in regular, you might just say, no, this is civil, we're not here to decide guilt or innocence. You know, here we're here to determine whether he should be held responsible and liable for these injuries that were caused to this person. So you have to make sure that those things are clear. And in doing so, we have certain elements that we have to prove. We have to establish these things. And you want to explain to them generally how that's going to happen. So you know, you want to tell them who you're going to hear from. Now, there's no set way that it has to be done, obviously. Most of the time, that's one of my first comments, which is that, yeah, I mean, technically, you're not going to get kicked out of court for what you just said. I mean, you can say that. You don't have to make one at all. The prosecution has to make one, but defense doesn't have to make an opening at all. So pretty much whatever you say, as long as you're not violating the rules, is okay. But there are certain things that have been deemed, I guess, to be, you know, the more persuasive methods to use and effective methods to use. And so that is one of the things that you should definitely try to do is when you're telling that story, obviously that's to familiarize the jury with your set of facts and what you claim happened, and hopefully it'll be believable and provable and consistent with undisputed facts. And of course, you never say anything, very important, you never say anything that can't be proven, especially if you know it can't be proven, you're doing it intentionally. And you never want to say anything that the judge specifically told you not to talk about because it's inadmissible. You know, there may have been a pretrial ruling or something on it. So, you know, you don't want to waste everybody's time and have a mistrial. So, so that's one of the first things. I mean, very, very important aspect. So tell the jury, of course, the last thing you do is tell them what you want. Tell them what you want. Real simple, just 3 little steps. You know, 3 little steps, but you add in the little filler. You know, just add in a little bit to go in the middle of it. Connect it all up. But if you're able to do that, you got a good opening. You've done what you're supposed to do. The main objection, yes ma'am?
In the opening for the law part, if you're on the defense, do you set up the law and what your defense to it is, or do you just go into?
Yeah, you really don't have to talk about the law as a defense, being that you don't have the burden. You don't have to really, you know, talk about that much. But if you have defense that has to be proven, you would want to talk about that, or the fact that that you know certain elements will not be proven. You might even ask the jury, you know, to look for this. You know, throughout the course of the trial, the prosecution has explained, or the plaintiff has explained that one of the elements that has to be proven is this. And, you know, I'll submit to you that there will be no evidence that will be presented on that issue. And I would ask that you look for that type of evidence and see if you find it. And so you really want to set that up for the jury to know what they will or will not see, who they will and will not hear from. There are some very important people who you will not hear from. You know, they talk to you about people you will hear from. We have a few additional people you will hear from. But there are some important people who you will not hear from. You're not gonna hear from the victim, you're not gonna hear from the eyewitnesses, you're not gonna hear from whoever somebody is that you're claiming that's the whole case. You know, bring those things, you know, really, the evidence that's gonna be presented, some evidence that may not be presented. Look for the physical evidence. You know, you're just telling them, giving them this roadmap, now they know, okay, well, let's see who we find. Let's see who we're gonna hear from. Arguing the case is objectionable. Of course, mentioning inadmissible evidence, unprovable evidence, giving personal opinions on merits. I mean, I think we got a case. I think he did it. All of that's wrong. You can discuss other sides' evidence, but in opening, if you don't know what they're offering, it's inappropriate to do that. You know, sometimes you really don't know until after they have that opportunity. So in opening, it can be a little tricky to talk about that. That's the main concern with that. Okay? So this is your opening statement checklist. Open with an attention getter. Tell a good story, your theory of the case. Your law evidence, the basis of liability, guilt, innocence, and how will or not be proved. And don't forget to ask for what you want at the end. At the end of this case, ladies and gentlemen, we ask that you find him guilty, not guilty. We ask that you find him liable, not liable. Something else that's important to me is that you reiterate your theme several times. We know that we want it in the beginning, but I don't expect to never hear it again ever in life. I mean, not anymore in the opening, not anymore in the trial, not anymore in the closing. I mean, I do expect that I'm going to hear it a couple of times more because remember, it's a theme. If we say right now that our theme for Law Week is going to be Hollywood glitz and glam, it's going to be everywhere. We're going to see it, you know, lights, in pictures of lights rather in the hallways. It's going to be on the invitations. It's going to be on, you know, in the titles of everything. You know, with red carpet photos. If that's the theme, it's supposed to be ringing throughout. That's what a theme is. So if your theme is going to be, you know, lost dreams, then some questions should come out about lost dreams in the, you know, and maybe at some point when you're asking whatever his name questions, at some point you might even use that word. What was your dream? Just so that you can keep the theme ringing through the case, you know. And what happened that shattered your dream? If we talk about shattered dreams, we would use that terminology. And what shattered your dreams? I mean, when that collision happened, that collided my dream, whatever. But, you know, it's a thing. So at the end of the case, when we're doing closing, at the beginning of the case, we told you that this is a case about shattered dreams. And we've proven that this is a case about shattered dreams. And so, you know, we want to reiterate that at the end. And then in the closing, we need to hear it a couple of times, you know, because it is the theme. That's why your theme needs to really embody what the case is really about, you know, because you should be talking about it a lot. If it doesn't really embody what the case is about, it's not going to make sense to throw it in there, you know, if it doesn't have anything to do with what the case is really about. So that's why you got to have a really good theme, because it should embody, when they think about it, it should be, yes, we're on his side, you know. And of course, don't argue. And it's very important that you don't talk about anything that cannot or will not be proven. So some things you don't know if it will or will not be proven. You're just waiting. You got your little, you know, list of responses to the objection, but you don't know how the judge is going to rule. So you just kind of wait and see, you know. So you can't talk about that. But if you really want to talk about it, it's very important what you do. If you know you want to talk about an opening statement. How many times I have to tell y'all the same thing?
Can you put it in your thing if you wanna talk about it?
No. If you wanna talk about it, you need a pre-what? A pre-trial ruling, so you will file a
Pre-trial motion.
specifically named
10.1.
a motion in.
Amendment.
Okay, so now how many times we gotta go over that? We have gone over that a few times. It's not changing. It's not gonna change. We talked about this about, September, October, November, December. Okay, almost 6 months. All right, so a pre-trial ruling, remember, eliminate at the threshold, that is the motion that you file to get a pre-trial ruling on the admissibility of evidence. That's the motion, and it can be on anything. It can be on hearsay, if you want, you don't know if it's coming in, if it's important enough to you, that you know you might wanna talk about it in your opening, or if you know, even if you don't wanna talk about it in your opening, it's probably, your whole case might be built on it. So, we gotta change the whole idea. If this isn't coming in, the whole thing, everything. So we need to know if it's coming in or not. So let's get this pre-trial ruling. Some things, you have to, for the most part, like statements, which will be, from the prosecution perspective, they're just gonna file a notice of intent. A notice of intent to use a defendant's statement. And, you know that typically it's gonna be set for a free voluntary hearing, but the defense would have also filed what motion to get the statement excluded? A motion to suppress, thank you. And so I was like, I bet not hear it. Okay, so the defense would have filed a motion to suppress the statement, and prosecution would have filed notice of intent to have it in. So it's gonna be the same hearing. And at the hearing, you establish that it's called a free and voluntary hearing in order to determine whether or not the statement was free and voluntarily made. Now, if the defense filed a motion to suppress, it would have to be set for a hearing anyway, because, you gotta have a ruling on it. And you call the police officer and talk about all the circumstances of, surrounding the making for the judge to determine whether or not it was freely and voluntarily made, or if it violates Fifth Amendment privileges. But at the end of the day, the prosecution has to always prove that a statement was freely and voluntarily made before it's admitted. But it doesn't have to be a pre-trial. It doesn't have to be pre-trial. It can be while the officer is on the stand. But obviously, the benefit, there's two benefits. The Code of Criminal Procedure specifically says that in order to talk about it in opening, it has to be a pre-trial ruling, obviously, unless you're gonna just stop in the middle of your opening statement and go and do it. So it has to be pre-trial to talk about it in opening. If you get it done pre-trial, then you can say, the first thing in your opening can be, I really don't know why we're here, because he already said he did it. You can really say it. But in any event, if you don't do that, then you have to establish that it was freely and voluntarily made, during the trial. But that's really important down here on things that can and cannot be proved in opening statement, because obviously, if you don't know, you can't say it. If you don't know, you can't say it. You could possibly do it. Okay, any questions on opening? I found the closing to be difficult for some of us. A lot of times we do just kind of get up and talk, but we don't understand what it means to argue the case and to argue the case in its entirety. And I hope we get some good openings. And just last night or maybe that was this morning, I was thinking, I wish I could have a couple of my students from last spring to come in and do their opening, who did it correctly. Because there were a couple of really, really good ones. But the reason why they were really on my mind is because I was thinking to myself, some students follow directions. I mean, like, even on final exams and things like that, you know, those of you who make the grades, you probably realize you do what you're asked to do. You know, the professor says organize it like this, you just organize it like that. Even if you think it's wrong, you just have to do it. You know, and so at least for that period of time. But we had some really, really good ones. Like we always have some good ones. Because I usually make a point to try to send an email or something to the students. We had last year, I actually selected a best advocate from the class, I have 2 sections obviously. And so I really was thinking I wish I could have asked 1 or 2 of those students to come in and give them. But I already told you I wanted you all to communicate your thing. But the next thing you need to do is to narrow the issues for the jury. What does that mean to you? Yeah, what does it mean to narrow the issues?
Just show them what to focus on specifically.
Yeah, I mean, you really just you show them exactly what they need, what really needs to be decided here. If it's armed robbery, you know, at the end of the day, we know the prosecution has to prove everything. But by some point, we all know what we're really arguing about. And sometimes you have to reiterate that, you know, that you have to prove, you know, all these elements, blah, blah, blah. And one of the elements, of course, is that we have to prove that there was a dangerous weapon. And then, you know, you're going to tell the definition. And whenever you tell them definitions involved, you know, make sure you let them know that the judge, at the end of the trial, in just a moment, the judge is going to instruct you on the law. And only what the judge tells you is the law. But what the judge is going to tell you is that, and you can even read it from the jury instructions, the judge is going to tell you that a dangerous weapon is defined as, read it to them, and you know that your issue here is whether or not the telephone cord is a dangerous weapon. That was used to strangle this person. And so you told them, you know, you narrowed the issue, and that's what you got to decide, whether it was a dangerous weapon or it was not. You know, and that may be one issue, there might be multiple issues, but of course that could be one of the issues. Or this is just a case, you know, there is no dispute that there was a rape. They don't even dispute that there was a rape here. We've proven that, and tell them how you proved it. Don't take it for granted. We've proven that. We have the testimony of this particular woman, and she said this, and blah, 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 we got rape. But the issue here, ladies and gentlemen, is one of identity. Who did it? Who did it? And there's been some evidence offered to show that it was Mr. Johnson, and there's been evidence offered to show that it was not. And I'm going to go through the evidence and show you why, you know, there's only one conclusion that you can draw today, and why it's Mr. Johnson, okay? So, you know, we've narrowed the issue now, right, to one of identity, you know, or one of, you know, at fault, just like we talked about in the Homer Simpson case. If the guy came in there with a screwdriver, more than likely he did lunge at this guy. If he had keys, he had no screwdriver, he had no reason to lunge at Homer Simpson with the keys. He couldn't have lunged at him with the keys. So it will prove that he's unreasonable in his actions. So what evidence do we have? That's where you go next, obviously. Which one has been proven? What has been proven? You say, I've narrowed the issues. Now, what evidence has been offered to prove that particular thing? The way I want you to do this, that is most effective, is to use a topical approach to making the closing easy to follow. And to give whatever it is that you're arguing, whether it's identity, to break your arguments up into categories and make it topical into, you know, there are 3 reasons why. 3 main reasons why we know that this is the guy. Or there are 4 main, they can be any type of points, any type of topics for finding in your favor. But remember I told you the other day about how the jury, you know, I talked to the juror, oh, well, you know, you're right. There was a lot of intense stuff there. Man, I wish you had just put it all together and made it into a nice little list then. well, that's the whole goal, for you to be able to pile it on and argue it in an organized fashion, okay? Now, one of the least effective methods is to argue this by witness. Well, this witness said this, you can believe her, blah, 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 blah. Now, you can do that, but you need to do it in the context of your overall points, your overall topics. You know, and so it might be a question of, you know, John said he got there at 5 o'clock, Bill said it wasn't until 8. Which one do we believe, John or Bill? Well, let's talk about John's testimony. John said this, and this. We can't believe John. Okay, too many inconsistencies. You don't have to believe John. The judge is gonna tell you that in the jury instructions. That if you don't want to believe, you don't have to believe any witness. If you believe that they're not credible. So you don't have to believe what John told you. Michael is the more credible witness. And this is what Michael told you. So based on these two witnesses, the only two witnesses we have who have given testimony or evidence on this point, it shows that we have proven he was here at 5 o'clock. So within those points, you're proving the subpoints. There are subpoints underneath that. Is this making sense? Okay, this is making sense. We got a couple people who look like they following me. Okay, so we talk about, and let me just take some of you all. And I'm gonna come back to this. But within those points, you know, we're looking at a topical approach to putting the information together. But within those points, under the topics, and when you start to prove what you have under those topics, it may be, there are 5 main reasons why you need to find this guy liable. 5 main reasons, or 3 main reasons, or 4 main reasons why you need to find Homer Simpson liable. Number 1, there was no threat in his life. Now, under that, what are some reasons why there were no threats to his life? Number 1, the guy had keys. Now, we know there's contradictory evidence, right? This is where the argument comes in, because now you got to prove that that he had keys. You can't just say they have keys, because the other side is saying he had a screwdriver. So it's not enough just to say, well, number 1, he had keys. What do you have to follow that with? He had keys, what? You got to argue it. What's some argument? We got some Homer Simpson people in here. Don't be scared. Where are you? Where are the Homer Simpson people? Okay.
We're saying he didn't have the keys.
You saying
He did not have the
he
keys.
did not? Okay. Why not though?
Because
Because
he's,
you're Vince.
right,
Okay, you're representing Homer Simpson, and one of your points is that you're saying that his life was threatened. And so that and we start talking about reasons why they need to find that he is not liable. And number 1, there was an overall threat to his life. Now, you may say there was a threat to his life, that at the time he killed, there was a threat to his life, and there may be reasons under that as to why his life was in danger at the time and why he was reasonable for believing that his life was in danger. Now, before you get to that though, you had to have done what? Thank you. You already started to learn my hand movements. Okay, so you have to narrow it down to that, because you just can't walk up to some people on the street and just tell them that, and that's what you're doing here. So you needed to have kind of gone through the law and said what the law requires that you prove or not prove. And now, based on what this law says, the main issue is, at the time he shot him, what this law is telling us, that if he reasonably believed that his life was in danger, or if that guy was in the commission of some sort of forcible offense against his person, then he's not liable, okay? And now there are several reasons why you should be able to find that he reasonably believed that his life was in danger, or the use of force was reasonable. And you can top it however you want to top it, depending on what it is, it's going to make your stuff under it differently. Because it would be different if you say, why his conduct was reasonable. Then you'd be like, okay, because he reasonably believed his life was in danger, maybe one. Number two, there was a forcible offense against this person. Number three, something else. But as you go back to your number one, that he was reasonable in his belief that his life was in danger. Why? That's why I like for you all to use your whiteboards. We got chalkboards, we got whiteboards in there. The jury, y'all see how easy it would be for them to remember these reasons? Instead of just talking random, throwing stuff all over this, a bunch of balls up in the air. And they'll say, well, they just told us the main, remember the main three things they said. It was, everything dark. 2 o'clock in the morning, black clothes, black hat, black shoes, black, everything, black car. So, basically, that's one thing, and also you all have that defense. You all have the fact that that he was negligent as well. The report negligent part, to bring that in there too. But what else? It was, and your reason might be all the circumstances. One reason why he was reasonable. Let's look at the context in which it occurred. We're in the middle of the night, we have him, and when you say these things, say how it was proven. You have to say how it was proven. You're not just talking yourself. It was the middle of the night. His wife testified. They heard dogs. He testified. There have been problems in the neighborhood, what have you. And he gets up, and he goes to get his gun, what have you, and now, in the middle of the night, we have a man standing out there in dark hat. There's no tow truck. They don't see a tow truck. Why? Because scary Lauren Jones had driven all the way down the street and dropped him off. Who comes to repossess a vehicle without a truck? So now we have this guy with the black ski mask on, and well, not a ski mask, whatever he's wearing, but it's all black. Number two, he has a weapon. Now, this is where your argument really starts because we have, contradictory testimony. So now you have to prove that your argument is what really happened, right? So now we have, let's look at the testimony that shows that, from your perspective, he had a screwdriver. Now we have a screwdriver found at the scene. Homer Simpson testified. We need to know the evidence to support it. Homer Simpson testified that he went out there, that the guy lunged at him with a screwdriver. He shot him, he came back in the house, fearing that if he had an accomplice, the accomplice would come back and get the screwdriver. He went back outside to get the screwdriver, and he brought it in the house. Now, when the police officers came, he showed them the screwdriver in the middle of the floor of the living room. But of course, there was he had a set that matched it. Now, the defense, or whoever the other folks are, the plaintiffs have brought out testimony to suggest that there was no screwdriver for a couple of reasons. One being the fact that they claimed he had a key, and obviously they also claim that where the screwdriver was found in the living room, it was beside a toolbox that had matching screwdrivers. So they have basically, asserted that these were my screwdrivers, and that I somehow came up with this story, in order to, fool the police and all this type of thing, that it was his set of screwdrivers, because that screwdriver matched the screwdriver that was in his house. So now, we need to show the evidence to show why that's not true. What do you have?
Why, what's
Why
not?
do we believe that this guy brought the screwdriver?
Because,
And it's not his,
Because
it's
the
matching the one, the whole tool set in his living room.
well, first of all, they didn't recover the keys. There was no keys found at the scene.
Okay, good.
If he would have had the keys, he could have just gotten the car and drove away.
Okay, so now we need some checks as to why we know he had the screwdriver. We know he had, because number one, how else was he gonna take the car away? He didn't have keys. No keys were found at the scene. No keys were found. Now, when you bring in these arguments, you gotta address the counter argument. Now, they may argue what? Well, you know, the keys were in your house, and that when you went back outside, you went to get the keys. And I think it is a good argument that clearly he laid in bed with his wife for 5 or 10 minutes talking about the fact that he heard the dogs. How long does it take to get out of a car, use some keys to get into another car and drive off? It's a matter of seconds. He clearly could not have had keys when he arrived at that house. So how was he going to get in the car? How was he going to get in the car? And that, to me, that, what else you got?
About this case?
Yeah, about the med issue. Because you have to do what? Ah, good, yeah, I'm getting real good with myself. You have to pile it on. You have to pile it on. You have to pile on these arguments. And most importantly, when you make these arguments, you have to show where some evidence in the case that supports what you're saying. And you have to address what they have said to counter it. So when you're talking about, well, you know, they're going to say, well, their key, you know, he had to have had keys because they're going to say that number one, you know, why not? We know that the owner of the place was there and the contract says that they keep a set of keys. He signed off saying that they can keep a set of keys. You know, the owner brought it. Why wouldn't the owner give him the keys? You know, and there was also no damage to the vehicle. So if he's standing out there with a screwdriver for 15 minutes, what was he doing with it? Because he hadn't made any attempt to get in the car yet. You know, so obviously these cases are intended for you to have different things to argue about, you know, but you gotta make those arguments. So that's just one thing. I mean, you know, all of this is under your, by the time you finish, hopefully you're saying screwdriver. But that's all under why, you know, now you got a couple points under there. You know, you got under why he was reasonable. You talked about the context of all of this black stuff. You talked about, you know, the screwdriver. And why else was he reasonable? Because he had no reason to think that they were coming to repossess the vehicle. That's part of one of their arguments. That he had every reason to think that they were coming to repossess the vehicle and that he should have anticipated them. But all the evidence would show that he was reasonable in believing that this was a burglary because he had no idea this was going to be a repossession. And why is that? Because he had tried to give him the car earlier, that very same day or that week, whatever the evidence is. But you get the point I'm making here, that it needs to be organized. You know, that's all I'm asking for, organization. In any way you want to do it, but in such a way that when I walk out of here, I should be able to say, as I have been able to do with certain people's closing, these are the 3 main reasons why. I mean, or, you know, the 4 main reasons why, or 2 reasons, or whatever it is. I mean, it should be easy. I may not know every reason under it, but it should be easy for everybody. You should be able to tell your partner, as we've had, you should be able to tell your partner really quickly what to do. You should be able to explain what is going on. Well, this is all I'm doing. I have my 2 main reasons, and these are the 4 this is the 4 points under that, and these are the 4 points under that. You should be able to explain. When you finish writing it, you should be able to say what I've done. Just like I just said about the attention getter theory of the case in law, you can explain. If you just got like 2 big old pages, well, what did you do? I was just talking about random BS for 2 pages. That's not a good idea. That is not a good one. You know, like random sentences everywhere. It's unorganized. It doesn't say anything. I'm just talking about it. Whatever comes to my mind next, free flowing, whatever. That's bad. It's not going to be good. That's how we're going to be when we read it. Okay. Yes.
Like time-wise, about how long should an opening and closing be? Is there like a?
It's as long as it needs to be. I mean, I don't have a time limit for me because I don't want excuses. Period. I can't have it. Well, I will put that in there, but I can get it in 4 minutes. No, if it takes you 2 hours, do it. I'm serious. I'll be here 11, 12 o'clock on Sunday night. I don't care how long it takes longer need to happen to do it. Now, when we're in class, at a certain point, I'll cut you off if I'm tired, you know, or we have to move on, just because of our time, but I have no limitations. And you really don't have any limitations in state court on time. You know, you can, I mean, the trials just aren't that big. I mean, if this was like a serial killer with 24 people, it might take you 2 or 3 hours or more. You know, but just a regular trial, it's only so much you can talk about anyway. So you're gonna be done in 30, 40 minutes, you know, with that. You know, when you arrive for court to do closings, you'll be there all morning doing closings between, you know, both arguments, rebuttals, and charging the jury. So that'll take you, you know, 3 or 4 hours anyway to do that. But yeah, when I want these things, it would be a lawsuit. I don't know what you would cut out. I don't know what I would cut out if I had to just say, oh well, you know, I gotta do it in 5 minutes. But you know, I just don't want, you know, to force you to be balancing all these different things. Okay, so we talked about this a little bit. Common sense arguments that make sense. I got a little bitty fan on my desk. I'm gonna have to bring it. I'm start just carrying it in my book bag.
It's not.
It's so high.
It's like maybe.
It's more.
I can't make it much longer. I'm still on my hot chocolate. Okay. So you gotta maintain credibility with the jury. Common sense. They heard the witnesses say, you know, they are hearing opposing counsel. And you have to remember it and keep in mind, it's very, very important, that, you know, at least tell yourself that they believe them just as much as they believe me. You know, they believe their witnesses just as much as they believe mine. Because sometimes you start arguing like the only thing that they hear is you. You know, he had the keys, blah, blah, blah. Okay, well, he said something else. You gotta address that. You gotta talk about that. Why that's not true. Why the evidence corroborates what we said. You need to bring that in. Use the evidence and visual aids, even for our presentation. We have the document cams. Well, that doesn't look like one. I guess that was what that was supposed to be. Oh, here it is. We have one of these in the other room. I guess they're about to install it. So you want to put your evidence up. You know, of course you're going to be using it in trial, but I want you to, I mean at the trial, but I want you to use them in here as well. So if you have, say for instance, same case, Homer Simpson, you want to show the jury and talk about, you know, this, during the police officer's testimony, he introduced this diagram of the front yard. And he showed you the route, or Homer Simpson showed you the route that he took to get from his front door all the way out here to this car. And on the other side, I'm sure they'll be talking about that. Reasonably believe that your life was in danger, but you went all the way outside to the end of the carport to confront this person when you were safely inside your home. That's reason number one right there, why you know, that you should be held liable and we're not reasonable in your conduct. But, you know, that's we want to see those exhibits. We want to see the visual aids. Our turn. Use them, you know, practice using them here. Practice using your visual aids that you're going to use in the trial. But keep in mind now, you got to pretend, and it's not going to be easy, but pretend the trial has happened. Okay? Pretend the trial has happened, and you're talking about, she told you this. He told you. When the officer testified, he said, you know, he told you this, what Homer Simpson said. So we want to, you know, feel like we have really just seen the trial. It's not easy to do, but try to remember that and keep that in mind. And, you know, use the exhibits. I want some of you all to practice using them. I want us to see them in play at this when we're doing it in class. We want to see some of those in play. Now, when we get to direct examinations in a couple of weeks, we're going to be reiterating, you know, getting them in and using them after we get them in. You know, that's my rule. You admit it, you got to use it. You know, you ask the police officer, bring it in, you admit it in the evidence, and then some of you are like, okay, now let me move on. I mean, it's like, put it out there and say, you mind stepping over to the put an X where you were standing. I was here. Put an X where she was standing. Well, she was here. What route did you take to get over there? I went here and I went there and I went there. Draw that. Let the record reflect that she's drawing her route with a green pen. When you come back to the closing now, we can talk about that. During the officer's testimony or whoever's testimony, she testified that she was standing way over here. Bob was standing way over here. This is the route that she took to get over there. This shows that she had intent to do whatever she wanted to do. You're using these exhibits now. You're using the physical evidence. Look at this knife or whatever it is. This is what she had. These are the gloves. All of that's in evidence now. The documents, you can read from the documents, all of that is in evidence. So use the visual aids in my family. Okay. Turn things, analogies, or metaphors in your favor. Take their impact away. Somebody did that. We used an example of that in class, right? We had a dream. Somebody said something about that. He took his own dream away, made it a nightmare, and have you. So turn them around. Turn their things around on them. Use it in your favor. The plaintiff has argued that this is a case about a company that refused to do business the American way, but it is the plaintiff who has not done business the American way, because these are the things that we've learned throughout the course of this trial. His own wife testified that he did blah, blah, blah. So use that in your favor. Of course, you want to avoid personal opinions. Argue the strength. Do not mention evidence that was not introduced or proven. Also, do not mention evidence that was excluded, all the inadmissible, the objections that came in and the judge sustained. Can't mention that. Definitely do not put the jury in the shoes of the victim. That is considered highly prejudicial and improper. Imagine, ladies and gentlemen, you're walking down the street at night. It's dark. Oh, you hear footsteps behind you. Objection is not coming in.
So, I have a question. I don't know if y'all seen that movie, Time to Kill. And the best part of the movie, he's like, was that highly prejudicial because he's feeling
he
this?
said, he said something about that. He went racial or something, right?
Yeah, he went racial.
Yeah, but it was, it's, a lot of it has to do with time and stuff like that, what's going on, whatever. And so, it would be something that would be prejudicial, because we talk about unfair prejudice. We're trying to evoke emotion and have a jury decide a case based on emotion rather than fact. And so, I would definitely say that it would, an objection would come, no doubt about it. An objection would definitely come, especially if that's not an issue in the case.
Can you put the jury in the shoes of the defendant?
I would think that would probably be unfairly prejudicial too, to say that, imagine if you were him, how would you feel if you were him? So they should be deciding the case on the facts. That would be an appropriate argument to make. You can always sidestep that type of thing. You don't ever want to go straight out like that. No one would want to be convicted of a crime that they did not commit. So they're thinking those things instead of saying, imagine if you were convicted of a crime, or if you were sitting there for a crime that you didn't commit. So that is going to be like, oh my God, yeah, I'm not guilty because I don't want to be guilty. So it's just going to be, even if they did commit it, they're not going to want to be guilty. So, but you can say things in a way that, no one would want that. No one would want to be sitting where he is. Kind of imply things, may keep it general, to avoid that. But people are going to put themselves in the shoes. Hey, people are going to put themselves in the shoes anyway. So, any questions about that? Now, they say don't instruct the jury, but you talk to the jury about the law, you talk to the jury about how they should interpret the law. So you should be talking about how to interpret the law, but one way you should do it, and the best way to do it, is to always preface any references to the law with the fact that the judge you on the law at the end of the trial. You're allowed, especially in criminal case, in civil cases, you use those. You know, people have the jury forms blown up and put on poster boards and tell them how to check. You know, you can go forward, you find these 3 checks, you can move on to number 5. And we're going to tell you how this needs to be filled out and why. You know, and so now we got this one, so you should be able to check for that. So you can use the jury forms, you can use instructions. And you all have civil cases with great instructions in it. And I want you to use the instructions. I should be hearing that, because there should be some law. You got to talk about law and opening and closing. So go to the back of your file, find that law, and I want to hear it. Because the law, all of your cases have some really good law in it. That's to like the elements, what has to be proven. Really good recitations of law in there. Okay. Let me see. Where was I? Oh yeah, but usually you want to tell them at the end of the trial, the judge is going to instruct you on law. And this is what the judge is going to tell you. Blah, 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 blah. Okay, so, and of course, you can explain it and let them know how they should interpret it based on your facts, obviously, you know. But you don't ever want to misstate it, especially when you know that you're doing it wrong. I mean, sometimes people might just not know, but don't misstate the law, don't misstate the evidence as to what has been found and what it says. Of course, no personal opinions, nothing excluded. You never want to appeal to bias, prejudice, and pecuniary interest. You know, you're supposed to argue a case based on the facts and the law that's been presented. Not based on some of these other arguments that I've heard this one attorney saying, you know, it's just not going to be fair that a person would have to, every time now that when they go apply for an apartment, they're going to have to say that they're a registered sex offender, you know, just because they were having consensual, non-sexual relationship with an underage minor. You know, it's just not right. So, no, that's not proper argument. Personal attacks on parties and counsel. Somebody told me I did a personal attack. I mean, I feel like it was a personal attack. But it was after. He didn't say it during the trial, but he told all his friends. And, you know, other prejudicial statements. Okay, so make sure you reiterate your themes. Reiterate your themes. We talked about that. We want to narrow, but this is your checklist. I give you a checklist for everything that we do. I give you a checklist for everything that we do. And if nothing else, you need to make sure you do what's on that checklist, because I'm going to be asking you about that. That's the only thing I'm going to ask you about. I'm going to say, well, you didn't argue the entire case. What about all this other evidence that was offered? You just going to throw that away? See, I'm not looking at this as some kind of little, well, I thought you just want to kind of see if we know what we're doing, no. This is, you need to act like this is a real case, and you need to argue the whole case. Sometimes stuff come out, I can tell you all now. I think the other day, I was like, wow, that was in the file? I never heard that before. Didn't I say that in class? Like, no, I never heard that before. I didn't even know that was in the case file. So, and that's because people just picking certain parts they like. In a real trial, you gotta argue everything. You need to look deep. All the evidence, what all these witnesses have talked about. So you need to really read that thing almost daily. Go through that file, you're gonna see new stuff that's gonna pop up in the file. Of course, deal with those weaknesses. So when you can bring out whatever about these keys, we need to know about that other side. Because you need to remember that the jury's listening to them and they believe them just as much as they believe you. So if they said it, they might believe them more than they believe you. So if they said the other side, you need to say why they should not believe that side. Rhetorical questions, I skipped that slide. Within your points.
No, you didn't.
Oh, I'm just going anywhere now. Number one, well, 2. Reiterate the narrow the issues. Got that? Organize into the points. That's the most important thing for closing. Everything else goes in a point. After you narrow the issues, that's what you should be doing next. Once you say say what the issues are. Now we need to organize your arguments to support why they need to find that issue in your place. That's all I'm looking for, organization, you know, into some kind of categories or something. Whew. I know, 5 more minutes. And you know, then the weaknesses, rhetorical questions within those points. So you might be asking, what was going on for the 5 hours he was in there? So then answer it. You know, making questions that you know that the people will want to know. You know, why would a person even be in a house? Why would they even be driving it? Where would anyone even be going at that amount, at that hour of night? You know, I think about that a lot. We were talking about that in criminal procedure. Woo! Yes.
Will we be deemed, if we do things, if we follow the checklist, but we do things that would necessarily be considered improper, but the other side doesn't object to?
I don't like improper stuff saying what they didn't object, because number one, I don't know if you know if it's proper or not. Like, there are certain things that, of course, I want in, and I'm not holding it against you because you offered some hearsay, you know, and yes, you want that in. But when you're just like improper, then I'm like, do you realize that's improper? Some things are so improper till I don't know if you know if it's proper or not. But some things, yeah, I know that you want to get maybe this description in that's like, yeah, you know, and you're gonna just say, hey, if they don't object to it, we want it in. Or even if they do object, if they don't know the right objection, it comes in. We have some basis to argue. But you know, some things may just get so far out there until it's way, way, way out. But if it's like reasonable, arguable, so to speak, then it's okay. You know, we have an argument for why like a reasonable argument. You never want to ever, as an attorney, do things that you know is wrong. See, I just got my credit for my ethics with the bar. That's my ethics. I said I bring it in. I said, how can you teach trial that without bringing in ethics and professionalism? So we get our 1 credit. So I bring it in here. But yeah, you know, you always want to make sure you're being ethical when you're doing this and not doing, because you have credibility is important. That's what it's all about. You're asking the jury to believe you just like the witness. And everything else is there. You see it. Any more questions?